Hey guys, so long time no see again. I've been so busy, but this first video I'll be uploading under labor law is actually under labor relations subject, and the first topic will be the right to self-organization. So it includes labor organizations and registration of unions, eligibility for membership, and special groups of employees. So we're not really going to discuss all of the articles included in the labor code, but more of the important ones that we have to remember by heart. So it's pretty short, but it's really quite long din kasi ang daming kailangan i-discuss the terms, i-discuss na mga exceptions to the exceptions. So ayan, let's begin. So Article 253 is the coverage and employees' right to self-organization. So all persons employed in commercial, industrial, and agricultural enterprises and in religious, charitable, medical, or educational institutions, whether operating for profit or not, shall have the right to self-organization and to form, join, or assist labor organizations of their own choosing for purposes of collective bargaining. So ano ba yung right natin to self-organization? Ito yung paggagawa ng mga union na nakikita natin when we get employed. It's either the company gives us the prerogative na sumali dito sa union ng company or may nasalihan na tayong ibang union, which we will discuss later on. So, ano ba yung collective bargaining? Collective bargaining is the process in which working people, through their unions, negotiate contracts with their employers to determine their terms of employment, including yung pay, yung benefits, yung hours of work, yung mga leave, yung mga job health and safety policies, ways to balance work and family, yan, yung mga terms of employment. So when there is a collective bargaining agreement, the duty to bargain collectively shall also mean that neither party shall terminate nor modify such agreement during its lifetime. However, either party can serve a written notice to terminate or modify the agreement at least 60 days prior to its expiration date. So it shall be the duty of both parties to keep the status quo and to continue in full force and effect the terms and conditions of the collective bargaining agreement during the 60-day period and or until a new agreement is reached by the parties. So the right to organize and bargain in general sense are given not exclusively sa mga empleyado lang. This is because even employees of any particular employer may form their organization to protect their interest. So organization enjoys protection under the Bill of Rights kasi nasa Bill of Rights natin to eh. So under this article, the right to organize refers also to forming, joining, or assisting a labor organization. The usual form of organization is a union and the usual purpose is collective bargaining. Ano yung exception dito sa all persons na sinasabi sa article na to? So, first we have the managerial employees, then we have the supervisors. Yung supervisors are allowed to organize, but they cannot form, join, or assist kasama yung mga rank and file employees. So the right to self-organization must be upheld in the absence of an express provision of law to the contrary. It cannot be curtailed by a CPA. So if the nature of the employee's job does not fall under the definition of managerial as per the labor code, they are eligible to be members of the bargaining unit and to vote in the certification election, which we will discuss then mamaya. Excuse me. So next we have Article 244, or the right of employees in the public service. So employees of government corporations established under the corporation code shall have the right to organize and to bargain collectively with their respective employers. All other employees in the civil service shall have the right to form associations for purposes not contrary to law. So ano ba yung first sentence dito? It refers to non-civil service employees. Ito yung mga GOCC. So yung mga GOCC are those without original charters incorporated under the Corporation Code. Tapos yung second sentence, it refers to employees under the Civil Service Commission. So for example, nasa employee ka ng City of Manila, you are under the second sentence. Your right to self-organization covers only the right to form associations for the purposes not contrary to law. So for civil service employees, you have Executive Order 180. So the executive order in Section 4 hereof shall not apply to the members of the Armed Forces of the Philippines, including yung mga police, yung mga firemen, mga jail guards, yan. Excuse me. So government employees have the right to organize and negotiate, but not the right to strike. So the purpose is for the furtherance and protection of their interests. The right of government employees is not quite extensive compared dun sa mga nasa private sectors. So itong right to self-organization, may twofold purpose daw to. So first is yung collective bargaining. So mag-organize kayo for the purpose of collective bargaining. Sinabi na nga natin kanina, yun yung mag-agree kayo na employer nyo na for the terms of the employment. The other one is for mutual aid and support. So if your purpose is for collective bargaining, you are called a labor organization. But if you fall under the second one, which is for mutual aid and support, yung tawag doon is workers association. So in collective bargaining, pag yun yung purpose mo, the right that may be acquired by the labor organization after registering with the DOLE and being recognized or certified as the exclusive bargaining representative of the employees. So, yung non-abridgment of right to self-organization naman. So, our Article 257, yeah, right. So, yung non-abridgment of right to self-organization, it shall be unlawful for any person to restrain, coerce, discriminate against, or unduly interfere with their employees and workers in the exercise of the right to self-organization. So, ito yung right na pag-join, pag-perform, yung pag-assist ng labor organizations. So the labor organization entitled to protection does not have to be a registered organization as long as labor organization siya. And it does not have to be a bargaining union. If hindi naka-register to, if it remains unregistered, it does not have a right to represent its members because it is not a legal person. Kasi nga, nakuha lang niya yung legal capacity niya once na naka-register na siya. So it cannot claim rights under the labor code. So the right to self-organization is granted not only to employees but to workers, whether employed or not. Constitutionally speaking, the right to form associations or societies is a right of the people, whether workers or not. So we go to Article 255 or yung ineligibility ng managerial employees to join any labor organization. Tapos yung right naman ng supervisory employees. So managerial employees are not eligible to join, assist, or form any labor organization. Supervisory employees shall not be eligible for membership in the collective bargaining unit of the rank and file employees, but may join, assist, or form a separate collective bargaining unit and or legitimate labor unions of their own. The rank and file union and the supervisors union operating within the same establishment, pwede silang gumawa ng same federation or national union, which we call as commingling, na legal na sa ating batas. So yung ano ba yung effect ng inclusion ng members of employees outside the bargaining unit? So inclusion as union members of employees outside the bargaining unit shall not be a ground for cancellation of the registration of the union. Said yung mga empleyado nito, kagaya ng sinabi natin sa article na to, yung manager employees, they shall be automatically deemed removed from the list of membership of the said union. Pero hindi automatically rin makakancel yung registration ng union. Matatanggal lang sila. The rationale for prohibiting managerial employees from forming or joining labor organization is that if these managerial employees would belong to or be affiliated with the union, they might not have loyalty to the union because there is conflict of interest. Furthermore, the union will be company dominated. Pero yung supervisors, as we said a while ago, baka pwede, pero sa federation or sa national union. Ano ba yung manager? So yung manager, they have the power to decide and do acts na nire-recommend ng supervisors. So may decision-making sila. And they hire, they transfer, they suspend, they lay off. Wait. Someone called. So anyway, yung managers ano ba sila? So the managers has the power to decide and do acts recommended by supervisors nga. So yun nga, decision making and hiring, transferring, suspending, laying off, recalling, assigning, and disciplining, and they also take part in policy making. Samantalang yung supervisor naman on the other hand has the power only to recommend managerial actions. So yung recommendation nila must not be merely clerical or routinary in nature. It must require the use of his independent judgment. So ano ba yung doctrine naman of necessary implication? So this refers to confidential employees. A confidential employee is one entrusted with confidence on delicate matters or with the custody, handling, or care or protection of the employer's property. Under the doctrine of necessary implication, confidential employees are similarly disqualified like managers. So in this doctrine, it means that what is implied in the statute is as much a part thereof as that which is expressed. So we go now to wait. Okay. We go now to the requirements of registration. So a federation, national union, or industry or trade union center, or an independent union shall acquire legal personality and shall be entitled to the rights and privileges granted by law to legitimate labor organizations upon issuance of the certificate of registration based on the following requirements. So yung requirements niya, one is 50 pesos registration fee, o di ba ang mura. Pangalawa, the names of its officers, their addresses, the principal address of the labor organization, the minutes of the organizational meetings, and the list of the workers who participated in such meetings. Third, in case the applicant is an independent union, the names of all its members comprising of at least 20% of all the employees in the bargaining unit where it seeks to operate. And fourth, if the applicant union has been in existence for 1 or more years, copy of its annual financial reports, and lastly, 4 copies of the constitutional and the bylaws of the applicant union, minutes of its adoption or ratification, and the list of all its members who participated in it. Sa charter naman, yung sa mga chartered local, a duly registered federation or national union may directly create a local chapter by issuing a charter certificate indicating the establishment of the local chapter. So upon issuance of this charter certificate, meron ng legal personality tong si charter. So the chapter shall acquire legal personality only for purposes of filing a petition for certification election from the date it was issued a charter certificate. So we go now to the grounds for cancellation of the union registration. So before kasi, mas sabi ni judge na yung prof namin, mas marami daw grounds before. Now, it's only limited to these 3. So kung yung grounds ng cancellation, sinasabi, hindi pasok dito sa tatlong to, hindi yun pwedeng i-invoke. So first ground is misrepresentation, false statement, or fraud in connection with the adoption or ratification of the Constitution and bylaws or amendments thereto, the minutes of ratification, and the list of members who took part in the ratification. Second, misrepresentation, false statements, or fraud in connection with the election of officers, minutes of the election of officers, and list of voters. Third is voluntary dissolution by the members. So dun sa huli, yung sa voluntary dissolution, the registration of a legitimate labor organization may be cancelled by the organization itself, provided that at least 2/3 of its general membership votes in a meeting duly called for the purpose to dissolve the organization, provided further that an application to cancel registration is thereafter submitted by the board of the organization, attested to by the president. So, yung collective bargaining, balik tayo, is a right that may be acquired by a labor organization after mag-register nito sa DOLE as an exclusive bargaining representative ng mga empleyado. 20% daw yung sabing registration requirement. Etong 20% na to, it applies to independent unions. A local chapter is created, once a federation issues a charter certificate. Sabi nga natin kanina, the chapter acquires legal personality. This is referred to as tentative legal personality. So what are the effects of registration naman sa DOLE? Ano ba magagawa nito? First, it makes the organization a legitimate labor organization, or LLO. Second, it has legal personality to demand collective bargaining from the employer. Third, it can petition for a certificate election. And fourth, it can hold a strike. So, pero nire-request din itong pagsa-strike. So, we go now to the rights of legitimate labor organizations. Actually, sobrang dami nito under the enumeration, but we summarize it into these 4. First is the political right, or the members' right to vote and to be voted for. Second is the deliberative and decision-making right, which is the members' right to participate in deliberations on major policy questions and decide them by secret ballot. Third is rights over money matters, which is rights against excessive fees, unauthorized collections of yung mga union fees, ganyan-ganyan. Fourth is right to information, which is to be informed about the collective bargaining agreements, and about the labor laws. So we go now to the check-off provision. Ano nga ba yung check-off provision? So, sabi dito, no employer in his own behalf or in behalf of any person shall make any deduction from the wages of his employees except for union dues in cases where the right of the worker or his union to check off has been, recognized by the employer or authorized in writing by the individual worker concerned. So check off is a method of deducting from an employee's pay at the prescribed period the amounts due for the union fees, fines, and assessments. So amount for union dues must be reasonable, hindi pwedeng sobrang laki. So yung assessments naman, like dues, may also be checked off. So yung dues, ano ba to? They are defined as payments to meet the union's general and current obligations. The payment must be regular, periodic, and uniform. While assessments are payments for special purpose, so may special siyang purpose, especially if required only for a limited time. The authorization should specifically state the amount, purpose, and beneficiary of the deduction. So in general rule, attorney's fees may not be deducted or checked off from any amount due to an employee without his written consent. Yung exception dito is yung mandatory activities under the code. So we go now to no, mali yung slide. Sorry for the commercial again. Yeah, tama na yung slides. Anyway, here, there are three methods to determine the exclusive bargaining representative. First, we have voluntary recognition. Second is certification election with or without runoff. And third, we have consent election. So una, punta muna tayo dun sa VR or voluntary registration. So VR requires three concurrent conditions. First, VR is only possible in an unorganized establishment. There is only second is there is only one union seeking for recognition. Third is that the union voluntarily recognized should be the majority union, as indicated by the fact that members of the bargaining unit did not object to the projected recognition. If no objection is raised, DOLI will be informed and the CBA negotiation will commence. If an objection is raised, the VR is barred and the certificate election will have to take place. There must only be one legitimate labor organization operating within the bargaining unit. So, kailangan isa lang daw. So, second naman, punta tayo dun sa certification election. Ito na yung most common and lagi namang sobrang daming cases na pasok dito kasi ito naman yung madalas na ginagamit. So, certification election is the holding of CE or certification election is the most democratic method of determining the employee's choice of their exclusive bargaining representative. Kasi election nga, so ibig sabihin boboto sila. Yung election dito nangyayari by means of secret ballot. So yung certification election means the process of determining through secret ballot the sole and exclusive representative of the employees in an appropriate bargaining unit for purposes of collective bargaining or negotiation. So the nature of the certificate election is an investigation of a non-adversary and fact-finding character. It is not bound by the technical rules of evidence. So it involves two issues. First is the proper composition and constituency of the bargaining unit. Second is the veracity of majority membership claims of the competing union so as to identify the union that will serve as the bargaining representative of the whole bargaining unit. So some of the employees may not want to have a union. Thus, merong tayong tinatawag na no union. So if yung no union yung mananalo, the company of the bargaining unit remains ununionized for at least 12 months, the period known as the 12-month bar. After this period, a petition for CE or certification election may be filed again. So yung CE is different daw from union election kasi union election is held pursuant to the union's collective bargaining and the right to vote is enjoyed by its members. The object is to elect the officers ng union. Dito sa CE or sa certification election, it is the process ordered and supervised by the Department of Labor and Employment of determining by secret ballot whether or not a majority of the employees wish to be represented by a labor organization, and in the affirmative case, um, by which a particular labor organization will be able to represent them. In certification election, all employees, whether union member or not, belong to the appropriate bargaining unit. Pwede silang bumoto. So the winners in the certificate in the union elections kasi become officers and representatives of the union only. While yung winners dito sa certification election is an entity, a union which becomes the representative of the entire bargaining unit that includes even the members of the defeated union. So direct certification is not allowed. The mere fact that there is no opposition does not warrant a direct certification. So sino yung nag-file ng petition for certificate election? So a request or a petition to hold certification election in an enterprise may be filed by a registered union or by an employer, which applies to OE and UE. So a national union or federation filing a petition in behalf of its local or chapter shall not be required to disclose the names of the local or chapter's officers and members, but shall attach to the petition the charter certificate it issued to its local chapter. Samantalang yun sa isa naman, the petition must be accompanied with at least 25% written support of the members in the bargaining unit. In union election, no requirement for support. So, saan ba pinafile tong certification election? The petition shall be filed with the regional office, which issued the petitioning union certificate of registration or certificate of creation of a chartered local. Petition shall be heard by and resolved by the arbiter. And where two or more petitions involving the same bargaining unit are filed in one, there is what we call, so next is yung conducting of a certification election. So, andun tayo sa process. So, we have pre-election conference. Here, nararaffle yung case to an election officer within 24 hours from the receipt of the notice of entry of judgment granting the petition for certification election. So within 24 hours from the raffle, the election officer shall schedule the pre-election conference, which should be within 10 days from the receipt of the assignment. The pre-election conference shall set the mechanics of the election. So yung list ng eligible voters, yung date and time, number and location ng polling booths, ganyan-ganyan. Kasi kung sobrang laki yung company, you really have to organize it. Then fourth, we have the failure to appear shall be deemed as a waiver of the right to be heard. Fifth is the posting of notice of the election at least 10 days before the actual date of election in two conspicuous places in the company premises. So we go now to the voters. So all employees who are members of the appropriate bargaining unit sought to be represented by the petitioner at the time of the issuance of the order granting the conduct of the certification election shall be eligible to vote. The list of voters should be based on the employer's certified list of employees in the CPU or payrolls. If the employer does not submit the payrolls, the union may submit their own list. Employees who have been improperly laid off, pwede silang bumoto. Probationary employees can also vote. May case dito na parang na-assail na bawal daw yung probationary employees or kaya yung mga tinanggal pending appeal ng pagkatanggal nila. But apparently they can still vote. Kahit yung mga na-promote na, pero hindi pa naman sila na-promote into managers or supervisors by the time na nagbobotohan, pwede rin yun. So the voting naman, on the spot questions, the election officer shall rule on any question relating to and raised during the conduct of election. Protests shall be recorded in the minutes of the election. Pagpunta tayo sa canvas ng votes shall be counted by the election officer in the presence of the representatives of the contending unions. Now we go to proclamation and certification. So double majority rule. So the number of votes cast must be the majority of the number of eligible voters. The union with the majority of valid votes cast, sila yung mananalo. So, kailan mag-fail yung election? Pag walang double majority. So, action on the motion within 24 hours from the receipt of the motion, the election officer shall immediately schedule the conduct of another certification election within 15 days from receipt of the motion and cause the posting of the notice at least 10 days prior to the election. So, magpe-petition sila ulit. Ano yung tinatawag natin? Ito naman, yung runoff election. So, when an election which provides for 3 or more choices, kung 3 or more choices yung mga union, results in none of the contending unions receiving a majority of the valid votes cast, and there are no objections or challenges, which, if sustained, can materially alter the results. The election officer shall motu proprio conduct a runoff election within 10 days from the close of the election proceeding between the labor unions receiving the two highest number of votes. So, kumari tatlo, tapos yung dalawa, sila yung nag-garner ng kumari tatlo, number of employees, lahat is sabihin nating 100. Tapos itong dalawa, sabihin nating tig 40 sila. Tapos 20 lang dito. So, wala nakakuha ng 50% kasi yung dalawang yon. So, magkakaroon ng runoff elections. So, anyway, the two highest number of votes, provided that the total number of votes for all contending unions is at least 50% of the number of votes cast. So, yung employer ba may say ba sila sa mga certification election? So, an employer is considered as a bystander. They cannot oppose the petition for certification election. He has no right or material interest to assail the certification election. He is allowed to protest against irregularities committed in the conduct of certification election. His participation is limited to 1. Being notified or informed of petitions of such nature, and 2. Submitting the list of employees during the pre-election conference should Med-Adverter act favorably on the petition. Tapos, itong pangatlo naman, under exclusive bargaining representative, we have consent election, not mentioned in the labor code, but authorized and detailed in the implementing rules. So, itong CSE is voluntarily agreed upon by the parties with or without the intervention of the DOLE. It may take place in an organized or unorganized establishment. If the parties agree to hold CSE, the results shall constitute the bar to the holding of a certification election for 1 year from the holding of the CSE. So last under this video is yung union security clause. Ano ba yung union security clause? So yung union security clause is a stipulation in the collective bargaining agreement whereby the management recognizes that the membership of employees in the union which negotiated said agreement should be maintained and continued as a condition for employment or retention of employment. So kailangan daw maging member sila ng union. The obvious purpose is to safeguard and ensure the continued existence of the union. Kasi pro-constitution naman to. It's for their protection also, for the employers' protection also, para hindi rin marami kausap nila. So ayun, union security is a generic term which is applied to and comprehends closed shop, union shop, maintenance of membership shop, or any other form of agreement which imposes upon employees the obligation to acquire or retain union membership as a condition affecting employment. This is to guarantee the survival of the union. It is an enforced membership. So we have yung closed shop agreement. So ito, prior to the employment of the person, bago siya ma-hire, kailangan maging part muna siya ng union. So only union members can be hired by the company and they must remain as union members to retain employment in the company. Is this absolute? Well, of course not. Kasi we have yung case ni Elizalde na it was against the person's religion na talaga na sumali ng union pero naka-close shop agreement sila. So paano yun? The Supreme Court settled there na syempre mas mataas yung hierarchy ng rights natin to religion. So, pwede siyang pinayagan siya kahit close shop agreement na hindi sumali din sa union. Second is we have maintenance of membership agreement. So, no employee is compelled to join the union, but all present or future members must, as a condition of employment, remain in good standing in the union. So, hindi ka pipilitin sumali. But, present and future members ng union, kailangan mag-maintain silang part ng union. Then we have union shop agreement. So non-members may be hired. But to retain employment, kung wala, hindi ka muna talaga sasali sa union, pero bibigyan ka nila ng specific number of time or a period of time, let's say 2 months, 30 days, ganyan, para sumali. The requirement applies to present and future employees. So question, paano kung may iba na siyang union prior to joining, tas wala pang CBA? So hindi retroactive ang pag-apply nito. If the employee is already under another union and sumali siya, and magkaroon ng collective bargaining agreement na dapat nga sumali sila dito sa union nito, hindi yun retroactively mag-a-apply dun sa mga dati ng empleyado pero may ibang union. Then we have modified union shop agreement. Employees who are not union members at the time of the signing of the contract need not join the union. But all workers thereafter must join. So perspective to, yung mga bago kailangan sumali. Then we have exclusive bargaining shop. So the union is recognized as the exclusive bargaining representative for all employees in the bargaining unit, whether union members or not. Then we have bargaining for members only agreement. So the union is recognized as the bargaining agent only for its own members. Then we have agency shop agreement, an agreement whereby the employees must join either the union or paid to the union as exclusive bargaining representative, a sum equal to that paid by the members. This is directed against free rider employees who benefit from union activities without contributing financially to union support. Bakit ka nga naman parang freeloader na magbe-benefit ka dun sa agreement pero hindi ka naman kasali? Then we have open shop, yung pinakalinyan sa lahat, which is an agreement which does not require union membership as a condition of employment. So the Union Security Clause is regarded by the Supreme Court as the most prized achievement of unionism. This is because the existence of the union will be assured and strengthened because everybody in the bargaining unit, whether he likes it or not, is compelled to be members of the certified bargaining union. And if all are members of that union, its existence, survival, and prosperity will be assured. The broad rule is that the union has the right to determine its membership and to prescribe the conditions for the acquisition and retention thereof. Consequently, admission to the membership may not be compelled. So, ayun. Ano yung exception dun sa close shop? Kagaya nga na sinabi natin kanina. Yung religion, ganyan. Tapos, yung exception naman dito, in case of labor unions holding a monopoly in the supply of labor, either in a given localities or as regards a particular employer by reason of a closed shop or similar agreements, in such case, qualified applicants may not be barred by unreasonable rules. Okay, so this ends my presentation, my short presentation. Sorry, medyo magulo and ang dami kong commercial, but I hope you learned something for labor relations under right to self-organization. So it's my midterm in a few hours. Wish me luck. Thank you, and don't forget to hit subscribe.